University in Idaho, but also doing some work now, I believe, for the Claremont Institute. I would remind speakers that we are aiming for under 15 minutes for each presenter so that we can not go much over an hour for the program length and leave time for question and answers after that. I've also reminded the speakers that the National Association of Scholars has a well-informed and intelligent audience, but not necessarily attorneys, not necessarily as familiar with constitutional provisions or the federal statutes that we'll be discussing today as you guys are. So please be mindful of their level of familiarity. Take the time to identify the statutes you'll be discussing or the constitutional provisions and to describe them. So with all of that said, and yes, a thank you to Chance Layton and Kaylee Gerard for recording this webinar. It will be on the YouTube channel for anyone who needs to bow out. And I would ask those asking questions at the end to use the chat function instead of the Q&A. That's just my preference. So with all that said, Professor Wax, we are going to turn to you for foundational remarks. You now have the floor.
Thank you, and thank you for inviting me to participate with such other distinguished scholars. The topic of my remarks is the role of due process and constitutional guarantees generally in addressing the rise of cancel culture in higher education. Now, it's no secret that higher ed is captured by a far-left progressive ideology, both by professors and administrators and to some extent students. And that ideology is peddled shamelessly to all members of the university. And universities continue to be fertile sites for cancel culture, that is, places where unpopular speech and speakers, both outsiders and insiders, are routinely excluded, shunned, punished, and penalized. The cancel culture operates through many different mechanisms, formal and informal, and potentially affects the freedom of expression of every member of the university, on campus or off. And that is part of what makes it so hard to fight, as my own experience attests, and I will talk about that in a minute. Now, it would take me much longer than the time allotted to detail the evidence that cancel culture is alive and well on campus. I will refer you to the excellent list compiled online by the Foundation for Individual Rights and Expression, or FIRE, of hundreds of incidents nationwide. And also the evidence compiled by British sociologist Eric Kaufman in his book, The Third Awakening, on the rise in censorious attitudes on campus, and especially among younger generations. But this panel celebrates Constitution Day, so it's right to ask, what does the Constitution and its guarantees have to do with campus cancellation? What immediately comes to mind, of course, is our First Amendment, which protects citizens from government suppression of speech. And then there is also the Due Process Clause found in the 5th and 14th Amendments, which prohibits government-sponsored deprivation of life, liberty, or property without due process of law. Now, the problem is a cursory examination of these provisions reveals something of which, alas, many people are only dimly aware. These provisions only protect people from government action, not from private action. They do not have universal application and generally do not regulate what private actors like many universities, corporations, and individuals do. The existence of these limitations point to an important, albeit currently contested, aspect of our society, and one which people like me who call themselves conservatives generally endorse, which is the line between the public and the private. Why is this line important? Well, one reason has to do with the Whiggish impulse. Big government, strong government, expansive government too easily becomes tyrannical government, compromising societies and citizens' liberty of thought and action. Alas, what this insight fails to take into account, and what perhaps the founders didn't fully anticipate, although that is contestable, is that modernity has thrown up private entities as big and powerful as government in controlling many aspects of people's lives to the point of despotism and the wanton destruction of liberty. This situation is nowhere more acute than in our modern universities. The wealthy behemoths with outsized influence on our culture, which shape and often warp young minds, and of course serve as the gateways to great influence. Of course, our university sector is divided into the public and private. Large, important universities are run by the states, Michigan, Virginia, etc., and they are directly regulated and limited by the Constitution. They must honor the First Amendment and the Due Process Clause, which doesn't mean they actually do. Such requirements must be implemented and enforced, which is arduous and difficult and meets resistance. But recently, some canceled professors have actually won lawsuits against public universities. Now, what about private universities like my own, University of Pennsylvania? Some of our most prominent institutions, including the Ivies, despite receiving enormous sums of federal money, are still considered private and are pretty much free to do what they want with a few isolated statutory limits, which I'll describe in a moment, and with no legal obligations to guarantee free expression or due process to their members. Now, of course, there are long-standing and formal traditions and understandings on academic free expression, but in light of the almost complete far-left progressive capture of our universities, these traditions have lately grown weaker and are inconsistently applied, as evidenced by the abandonment by organizations such as the American Association of University Professors of long-standing rules of neutrality and academic boycotts. Needless to say, these traditions need to be revitalized. Now, it is the case that some private universities have voluntarily and openly adopted various protections for its members, or at least they have purported to. I'll give you an example. Our now deposed President Liz McGill, that is, president of Penn, told a congressional committee back in December during a hearing on campus activities in the wake of the Hamas October 7th attack on Israel that our university voluntarily applies First Amendment standards to speech on campus. That was an astonishing statement that has never been walked back, and as their case against me starkly illustrates, it is cheap talk. Their actual practices fall far short of First Amendment standards. In fact, Penn's policies and practices relating to freedom of expression, including pronouncements in the wake of October 7th, are a confused mess. A dog's breakfast of equivocation and long-winded highfalutin pronouncements that are short on specifics and long on feel-good rhetoric. The bottom line is that no one knows what they can or cannot say about anything. There is no clarity, nor rhyme or reason, no consistency, and perhaps that's the way they want it. Now, some scholars, like Cass Dunstein of Harvard, Keith Whittington, now of Yale, have tried to speak in plain English about what First Amendment doctrines mean for campus speech and what rules they think should apply. I don't agree with everything they say, but in my opinion, they get most things right, and at least they give concrete examples and guidance and face up to hard cases. But the bottom line is this. Even when private universities purport to respect strong rules of free expression, they routinely flout them, or they apply them in partisan ways. And there is no one to hold them to account, and few willing to do so. The due process question is in some ways even harder. What is due process? Where is it defined? Much of the law is in formal understanding and practice, but if you delve into the actual case law, you encounter a core idea. Due process exists to get at the truth, to reduce the risk of error, of outcomes of cases, as stated in the landmark case of Matthews v. Eldridge, and produce a correct result under the substantive laws and rules that apply. And of course, that assumes that such rules and standards have been defined. Due process exists to get the answer right. But according to the Supreme Court, there is no rigid formula for what is deemed due process in every context, and these flexible standards provide a lot of leeway and discretion. However, given the ultimate purpose of getting the right answer, due process cannot just be an empty promise, a matter of jumping through arbitrary hoops. Rather, it involves examining evidence and facts and evaluating them objectively and fairly and giving an explanation for a decision. Now, my own case and many others illustrate that that often simply does not happen. And for private universities, there is certainly no a priori legal or constitutional requirement that due process be honored. Once again, as with free expression, private universities often pretend to take on due process type obligations. For example, my faculty handbook, which applies to professors like me who are accused of various types of misconduct, say there is an entitlement to fundamental fairness and proceedings that provide due process for evaluating claims. Now, unfortunately, those promises don't mean much if the universities don't want them to. They can easily degenerate into a toothless performance that offers little or no protection. Once again, this is illustrated by my own case. My university brought charges against me based on opinions I expressed, both inside and outside the university, of which the university disapproved. And tacked onto them just for good measure were a handful of allegations that I, quote, abused students. I can assure you that those latter accusations were bogus. They involved purely fabricated incidents or putting words in my mouth to change their meaning. I will give you one example and show how the supposed due process the university extended to me just didn't do its job. One of the witnesses for Penn during a 3 days long hearing on the charges against me, held in 2023, was a 30-something Penn Law graduate, a black woman, who had been in my first year civil procedure class back in the 2000s, more than 15 years previously. And of course, I didn't remember the student who was one among many hundreds I taught. She claimed that every day in class, I would come in and devote 15 minutes to expounding on my book about race. And I lectured the class on race, even though it was civil procedure. And this, she claimed, was abusive. By the way, this allegation was not even listed in any of the written charges against me. It came with no warning at the time of the hearing. So much for due process. However, during her testimony, the same student also offered that she was suffering from mental health issues her first year, and occasionally even experienced hallucinations. Nonetheless, the faculty hearing board, in its decision, stated summarily that all allegations of all the university's student witnesses would be fully credited. For this woman's testimony, among others, there was no assessment of credibility, counter-evidence, corroboration, or other standard analysis of her claim's plausibility, including the fact that my book wasn't even written until 2 years after she was in my class. And the hearing board's decision never even mentioned or referred to any of the students who testified on my behalf. Now, I think it is abundantly clear that this hearing board did not accord me due process under any defensible, commonly understood meaning of that term. And even more egregiously, the board never defined the substantive standard or supposed university rule I violated, under which I was to be evaluated. But of course, process is meaningless without a rule or standard that the process is supposed to guarantee. Without that, due process cannot be designed to get at an accurate result because there is no benchmark for accuracy. Without that, due process is empty. It is just going through motions. It is due process in name only. Now, will the university committee who heard my case get away with this? Will the sanctions based on these findings stand? The answer remains to be seen, but I am not optimistic. The concept of fundamental fairness and due process as applied to faculty and others at my university is so ill-defined that it is easy to render it a nullity by ignoring its core purpose. For private universities, there are many obstacles to an honest process. It is harder to get courts to police and enforce private university actions as opposed to public, if only because limits on private universities are almost always contractual and self-imposed, and the Constitution doesn't apply directly. And many judges take a highly deferential attitude towards private university affairs, even conservative judges. And there is little concrete law on what tenure means and the protections it offers, and the universities are eager to claim it means as little as possible. So in light of all these limitations, what can be done? Can we bring these powerful private universities to heel? I will just touch on a few ideas here, and I'm sure other panelists will expand on it. Right now, the most promising area looks to the fact of federal funding. As I've said, these universities get hundreds of millions of dollars, but according to the courts, that doesn't make them public. That doesn't mean that they're subject to constitutional constraints. But there are other limits in the law that relate to funding. And of course, the most important one is Title VI of the Civil Rights Act. Entities receiving federal money cannot discriminate based on race, sex, or other categories. But of course, that doesn't impinge on discrimination against viewpoints, opinions, expression. I think there is a compelling argument that Title VI should be extended to require universities to honor the First Amendment, just as public universities do. And the law should allow university members to sue to enforce those rules. That is critical, having the right to bring a cause of action. It has also been proposed that universities be required to trim their administrative staff, to abolish their diversity, inclusion, and equity departments, and that they be forced to establish rules of color blindness and identity neutrality in all of their activities and decision-making. Finally, Title VI could be extended to make disciplinary procedures subject to robust, clear, and transparent due process standards, with judicial oversight and, once again, the right to bring actions in court for violations of these protocols. None of these measures will solve all the problems, but they will help. Of course, we cannot look to any Democratic administration to implement or sponsor any of these changes. Excuse me for being partisan, but that is the reality. Only the Republicans, and only some Republicans, even purport to care about the pervasive abuses and partisanship in the educational system generally, and in higher education in particular. Higher education is too much of a sacred cow, even among conservatives. So highlighting these problems and abuses and elevating them to a political priority should become a vital project on the right. What is the most important reason for this? For the students' sake. They deserve better. They deserve a more balanced education than the one-sided, tilted indoctrination that they are currently getting. Thank you.
Thank you, Amy, and I'm especially grateful for your pointing out the necessity of state action. I used to say the Constitution was a document that governed government. So it requires state action. It's a protection of citizens, so doesn't technically apply to private universities, although you've laid out why it could. And the second point about these are not self-enforcing rights and liberties. Lawsuits are often required to enforce them. So thank you for making those threshold points. I'd like to turn now to Professor Thomas Powers for a discussion of Title VII. Please, Professor Powers.
Thank you. It's an honor to speak today in the company of scholars who know as much about civil rights law and the Constitution as Shep Melnick, Amy Wax, Scott Yenner, and our moderator, Teresa Manning. In addition, the experience of Amy Wax and Scott Yenner reminds us that speaking the truth about these issues can come at a real cost. The integrity and personal courage of Professors Wax and Yenner is truly inspiring, and we are all in their debt. The history of civil rights reform from 1954 to the present is to some considerable degree a history of constitutional conflict. The civil rights revolution has put considerable pressure on a wide array of constitutional principles, to include freedom of speech, freedom of association, the public-private divide, due process, and the separation of powers. Now, today, at the present moment, two important developments might seem to suggest a shift in a different direction. First is the landmark 2023 Supreme Court decision, Students for Fair Admissions versus Harvard, which struck down the diversity justification for affirmative action in higher education. Second is the ambitious effort by more than 20 state legislatures to push back against wokeness and DEI, or diversity, equity, and inclusion, especially in higher education. Now, this very brief sketch of our current situation is accurate up to a point, but it misleads somewhat. First, by emphasizing constitutional law. One thing I've learned from Professor Melnick is that civil rights statutes have been much more important than constitutional law to the development of the anti-discrimination order. At the same time, red state efforts pushing back against DEI, as important as they are, do not touch any aspect of federal civil rights law. And that's a problem because, as we shall see, federal civil rights law is the ultimate source of DEI bureaucracies, DEI training, and other DEI efforts. Now, understanding two key areas can teach us a great deal about the complex whole that is civil rights law. Title VII of the 1964 Civil Rights Act, which governs discrimination in employment, and Title IX of the Education Amendments of 1972, which regulates sex discrimination in higher education, have done much of the lifting, the heavy lifting, to build our current woke order. Since Professor Melnick is discussing Title IX, my remarks will focus on Title VII, which I take to be the center of all civil rights law. Now, the key to understanding both Title VII and Title IX is to track their great expansions over time. Nobody in 1964 or 1972 could have predicted that the fight against discrimination would become what it has become today. I'm going to look at 5 major expansions of Title VII to illustrate this, I think, very vividly. Now, I am going to be talking about a lot of legal history here, but I want to show that it's possible to summarize the basics of Title VII in less than 15 minutes, and I've timed this presentation. It's under 14. Americans need to understand civil rights law better than they do, and I want to demonstrate that it's actually much less complicated than you might think. We know a lot about constitutional law, but we really don't know much about civil rights law. And that, to me, is very strange because civil rights law, in a way, is as important as constitutional law is today. Following Professor Melnick yet again, I note that none of the 5 major expansions of Title VII that I'm going to talk about were set forth by Congress in legislative enactments. They're all reinterpretations of the law devised by the civil rights bureaucracy and then consecrated by the federal courts and then ultimately by decisions of the United States Supreme Courts. The first of these expansions occurred when the legal definition of discrimination under Title VII was extended beyond what is called disparate treatment to include something much broader, what is called disparate impact. Now, that distinction may sound annoyingly legalistic, but it's very important. Disparate treatment refers to obvious intentional acts of employment discrimination in hiring and firing and the like. Disparate impact, on the other hand, focuses on inequalities between groups in jobs or pay or educational attainment. Taking these group inequalities as its starting point, disparate impact makes the extremely controversial claim that even if there's no intent to discriminate involved, any such group inequality is discrimination under the law. That interpretation of Title VII first appeared in the 1971 Supreme Court decision, Griggs versus Duke Power Company. The second important expansion of Title VII was to claim that something called harassment is discrimination under the law, and to include under the category of harassment the idea of the hostile work environment. This became bedrock law in a 1986 decision, Meritor Savings Bank versus Vincent. The third was to insist that discrimination be expanded yet again to include stereotypes under Title VII in a 1989 case, Price Waterhouse versus Hopkins. Let me pause here to belabor what by now may seem an obvious point. All three of these steps altered the meaning of what discrimination is, expanding that concept well beyond anything originally intended by the framers of the 1964 Civil Rights Act. That leaves our fourth and fifth expansions, which are usefully treated together. Number 4 was a significant expansion of something very boring, employer liability. Boring, but very important. Largely as a result of the new prohibitions on harassment and stereotypes, employers became responsible not only for their own policy decisions, like hiring and firing, but also for any and all discrimination taking place anywhere between anybody in the workplace, whether work-related or not. Understandably, under this circumstance, employers sought some way to protect themselves from liability. The answer they received back from the EEOC and the federal courts is our fifth expansion. Employers must, on their own, take, quote, preventive and corrective measures, unquote, to police discrimination in the workplace. Preventive measures include a host of tasks: formulating and publicizing internal company policies, assessing workplace climate, monitoring bias reporting systems, investigating discrimination and harassment claims, adjudicating appeals, and keeping records. And then, of course, there's the most visible preventive measure of all, diversity training or DEI training. Title VII's new corrective measures are at least as important as those preventive measures. These corrective measures extend anti-discrimination law enforcement down to the level of the individual and with maximum force. As a 1999 EEOC guidance document put it, workplace correction would include, quote, oral or written warning or reprimand, transfer or reassignment, demotion, reduction of wages, suspension, and discharge. These two last expansions were given the blessing of the Supreme Court in a pair of 1998 cases in what is known as the Ellerth-Farragher employment liability test. A year later, the High Court insisted again, even more clearly, that employers must provide what today we call diversity or DEI training in Kolstad v. American Dental Association. Nobody has heard of these cases, I suspect, but they're very important. Hopefully by now you can begin to see why I suggested earlier that Title VII is the center of all anti-discrimination law. I want to conclude by highlighting briefly what I think are the most important ways in which these expansions of Title VII challenge or contradict the spirit of our liberal democratic constitutional order. The challenge can be summarized under two broad headings. First is the requirement in the law to see and to do something about tangible group inequalities. One might say that there's a massive legal contradiction here. On the one hand, the Supreme Court has banned affirmative action as a group inequality remedy under the 14th Amendment. But then, on the other hand, group equality thinking is actually institutionalized by the Title VII disparate impact regime. This is a contradiction, and a very consequential one. When quotas are not an option, The alternative strategy taken by disparate impact policy is to reject any standards that do not produce equal results for groups. Those standards, student aptitude tests, grading, credit and criminal records checks, and the like, are the basic building blocks of middle-class life. The logic of disparate impact law is totally foreign to basic assumptions of our constitutional tradition, but it's alive and well in America today, advancing often under the heading of equity. Disparate impact is indeed the heart and soul of the Biden administration's, quote, whole of government equity agenda, to include some 300 new equity initiatives launched by the federal government since 2022, and the insertion of new equity teams into more than 90 agencies across the federal government. Beyond this politics of group equality, there's also a second broad category of the effects of Title VII's expansions. In my opinion, this has not been named yet in an adequate way. The best term for it today is probably wokeness, a useful but also decidedly ambiguous term. A more cumbersome but more accurate label might be the following mouthful: civil rights law's aggressive use of privatized enforcement, punitive correction, and moral and political training. However we name it, the second phase of civil rights politics is to some significant degree the combined result of all of the last four expansions of Title VII that I mentioned: harassment, stereotypes, expanded liability, and preventive and corrective measures. Those four legal changes taken together have meant that civil rights enforcement has become almost wholly privatized, turning the public-private divide on its head, very similar to the point that Professor Wax was making. Without fully realizing it, we have made a world where fellow citizens, acting in a quasi-public, quasi-private capacity, police one another and mete out punishments that are not inconsequential. Another thing we need to see better than we do is the amazing ambition of the campaign to end harassment and stereotypes. Now, I assume that this will be a permanent feature of anti-discrimination law moving forward, but we need to admit and reckon with the fact that regulating harassment and stereotypes is unavoidably an effort to regulate society and our social and interpersonal relationships. We need to admit as well that it entails an effort to change the way that individuals think about one another in what amounts to a program of direct civic and moral education. Finally, it almost goes without saying that all of this requires a good bit of censorship. Amazingly, the Supreme Court has never addressed the question whether Title VII's policing of harassment and stereotypes through the privatized enforcement of civil rights law constitutes political censorship under the First Amendment. In the 1990s, there was some discussion of this. Eugene Volokh made a case for it back then, but it went nowhere. All of this taken together, by the way, is what we mean when we talk about DEI. DEI training is, to begin with, Title VII training. DEI bureaucrats exist mainly because somebody has to do all the work required by Title VII's preventive and corrective measures. This matters today because so long as anti-DEI efforts do not touch the basic architecture of federal employment discrimination law, the prospects for the long-term success of the anti-DEI campaign will remain in doubt. The tension between the expanded Title VII regime and our traditional liberal democratic constitutional understanding of things offers a warning sign that we cannot ignore. It is, of course, true that race discrimination in 1964 was an evil that had to be confronted forcefully. The Civil Rights Revolution was a transformation of immense moral power, and its basic achievements are here to stay. But that moral reform movement, we can say now, had many unintended consequences, not all of them for the good. It is up to us today to reconcile this new order of things with the best features of our constitutional tradition. And that means that what is needed is a broad project of civil rights reform moving forward. And for that to succeed, we are also going to need to educate the general public about how anti-discrimination law has changed the contours of our social, political, and moral life. If we are going to make progress with this dual task of civil rights civic education and civil rights reform, it will only be on the basis of an understanding of how anti-discrimination law has expanded well beyond its original meaning and intention. Thank you.
Tom, thank you so much for that excellent description of what has happened with Title VII expansions. I've never heard it put quite so succinctly. I can't say the same about the mouthful expression, earful expression you gave us. I would suggest thought police, but let's save that for the discussion. Let's turn now to Professor Melnick for a discussion of Title IX, not Title VII. Professor Melnick.
Thank you. I appreciate being invited to participate in this. As you will see, I'm probably the most left-leaning member of this panel. I'm not usually in that situation, and I enjoy being in this position. So let me just start off by the question of why it is that in a Constitution Day discussion, we're talking so much about civil rights statutes, not saying as much about the Constitution as statutes. Now, one reason that we for the discussion of statutes as well as the Constitution is that when we're enforcing and interpreting these statutes, we very quickly run into other aspects of the Constitution. Amy laid out all of the due process questions that come up, especially in Title IX harassment cases, but also in Title VII harassment cases. The free speech implications of as Tom pointed out, moving to this anti-stereotyping understanding of discrimination. Another feature is that all kinds of federalism issues are raised as the federal government tries to put restrictions on what state governments and local governments can do. The problem of unfunded mandates. But I think even more importantly, and this is I want to make 2 points in this regard, is the fact that constitutional interpretation and statutory interpretation are very closely intertwined. And that we tend to transpose ideas from one to the other. And what that means is that judges are no longer the only ones that are basically establishing the principles of what the Constitution requires, because this is a conversation in which administrators, largely, every once in a while, Congress is engaged in determining what our basic rights are. Now, why is that? It's largely because the wording of these crucial civil rights statutes is so close to our understanding of the Equal Protection Clause. I was advised basically to say, let's be clear about what these laws are. I'll just say quickly that I'll be talking a bit about Title IX, which applies only to discrimination on the basis of sex in institutions that receive federal funds. Those are both federal, state and local, but they're also private colleges, almost every private college in the country. Title VII applies to employment discrimination, not just on the basis of race, but on the basis of sex as well. And that applies to private employers primarily. And that was one of the big steps in the Civil Rights Act to say, we're going to go beyond state action to private action. And Title VI that Amy mentioned briefly prohibits discrimination on the basis of race or national origin in any institution receiving federal funds, which again is any public institution, but almost a wide variety of private institutions as well. So let me make my 2 points about the politics of this intersection of constitutional and statutory. And just to kind of give you an idea of what I have in mind here, some of you might be familiar with the Bakke case on affirmative action. That's where the famous diversity rationale came into existence. The dissenters in that case didn't talk about the Constitution, or at least the Rehnquist dissent. They said this is clear, affirmative action is clearly prohibited by Title VI. The statute, I think, was much clearer on that than the Equal Protection Clause. But the majority basically said, oh, no, we're going to talk about the Constitution. Conversely, in the Weber case on affirmative action and employment, the majority, Justice Brennan's decision, in order to allow affirmative action, really distorted the statute beyond belief to achieve what I think was their constitutional vision of what equal protection requires. So it can go in both directions. So the first point, how do we see agencies playing a role in the way which courts end up seeing constitutional issues? One clear example of this is with desegregation in the 1960s under Title VI, where basically the courts relied upon HEW, Health, Education, Welfare Departments, understanding of the targets that schools had to meet to be considered desegregated. The Secretary of HEW at the time said courts and agencies have to go on parallel tracks at the same speed for this to work. And generally they did. But then the agencies, for I think understandable reasons, said we need numeric targets, and the courts embraced that. And then that became a crucial part of the court's understanding of desegregation. Title VII, Title IX, I've described a number of instances of what I call institutional leapfrogging, where the agency will take a small step, the court will endorse that, the agency will then take another step, the court will then go a little bit further. So you get a bunch of incremental expansions. So you get a major expansion overall without anyone agreeing that they've done anything new. But often this then gets embedded in people's understanding of the Constitution. And as a leading example of that, I would point to some of the recent federal court decisions on the transgender issue. I think about 10 or 15 years ago, it would be hard to find a court would say that there's a constitutional right to be assigned to the sports team that matches your gender identity, even if it's different from your biological sex, above all, your testosterone level. But that's what a number of courts have been saying in recent court decisions. I think that would not have happened if they had not seen the agency taking the step first, then courts accepting that interpretation of the statute, that becoming accepted, and then that becomes read into the Equal Protection Clause itself. Now, so that's my first point about the way in which agencies and courts build upon each other in the expansion of the regime that Tom just described in some detail. The second point I want to make is that over the past 14 years, there's been a change in the nature of this relationship between courts and agencies. I was surprised when I went back and looked at the history of guidelines by the Office of Civil Rights, OCR, and the Department of Education. And I realized that between 2010 and 2016, the Obama administration issued more significant guidelines in various forms, guidance documents, dear colleague letters, etc., than Office of Civil Rights had issued in the preceding 40 years. And the Biden administration has basically provided guidance at exactly that rate. So we got a huge acceleration of federal regulation during those years. Conversely, during the Trump administration, we had an unprecedented level of withdrawing many of those regulations. We have a more flip-flopping than we've ever seen before. Now, in the past, the pattern was that Democratic administrations would slowly add a few more requirements, engage in relatively aggressive enforcement, and then Republican administrations would come in, not issue any new regulations, focus on quick resolution of complaints to show they're being very efficient, and less aggressive enforcement. But the Republican administrations would not reverse previous rulings, guidelines, dear colleague letters. So you got this ratchet effect. But what we're seeing now is the aggressive regulation of Democrats and the unprecedented extent to which the Trump administration reversed many of those policies. And I suspect that if Trump gets reelected, we will see that once again. The other thing that we've seen in recent years is increasing disagreement among the courts of how to respond to this. Sometimes the courts have engaged in the typical leapfrogging. other times they've said no. That, for example, the best example is the large number of injunctions against enforcement of Department of Education's 20 and 24 regulations, which are extremely extensive, on Title IX. Those have been enjoined in 26 states and colleges in many other areas of the country, including Boston College, including Harvard, states that are not covered by the injunctions. And you have other courts that are saying, no, this understanding of transgender rights applies in the Constitution. You have conflicts among the circuits. You have Democratic attorneys general, Republican attorneys general challenging virtually every one of these major sets of regulations. The Supreme Court will be asked to resolve many of these issues, something it has rarely done before. The Supreme Court doesn't weigh in on these issues very much. And how the court is going to deal with all of these conflicts and these national injunctions remains quite unclear. But the point I would make and close with is that what we're seeing in civil rights law is a broadening of the scope of conflict into partisan politics. I don't actually think that's terrible. I think that these are important issues that should be debated and should be in the political arena. But we are not just a deeply divided nation, but a very closely divided nation. And that applies to the courts, and that applies to who controls the regulatory agencies. So these constitutional issues have become more open to political disagreement. I won't say than never before, because we have had some major periods of constitutional disagreement in the political arena. But think about what those times were: 1800, 1860, 1935. And in each one of those instances, as political scientists will tell you, we had a realigning election. We had a new political coalition that basically could set the rules, this understanding of the Constitution, for the next 30 or 40 years. And that was clearly the case. This time, that's not true. I think it's extremely unlikely that either party is going to get a dominant majority for a long time to come. So these issues in which Congress, administrative agencies, and courts all participate are going to be highly divisive for a long time. And that's a major change in civil rights policy and civil rights law. So I'll close with that. Thank you.
Thank you so much, Professor Melnick, to describe the interaction between the courts and the agencies. You didn't mention what seems the elephant in the room. We can discuss this more later, the democratic legitimacy of having so many fundamental matters decided by unelected, in some sense, insulated people. And that gets into the cult of the expert. But it's funny, when I was in law school, judicial activism was the big cry and lamentation. But now we have an agency activism, agency overreach, and you've really expertly described how they don't coordinate but interrelate. So thank you.
Yeah, if I could just add, I forgot, you sparked my memory on one thing, which is that there is this question about the legitimacy of the administrative state.
Right.
But there's also the increasing question. I probably hang around with more Democrats than you guys do, but what I hear all the time, and I'm shocked and disturbed by, is questions about the legitimacy of the Supreme Court.
Right, a topic unto itself. With respect then to democratic overtures or democratic legitimacy, what the states maybe have been doing, which Professor Melnick mentioned, but we'll turn to Scott now. Of course, Scott, you can address whatever aspects you would like, but if you can touch upon that, we'd all be grateful. So the floor is yours now.
Yes, and thanks to NAS, and thank you, Teresa and Chance, for organizing this, and thanks to my fellow panelists for the great papers. And I do want to talk about federalism and civil rights and federalism. Today, I think there was kind of an interesting episode where the governor of Florida, Governor DeSantis, has decided he's going to press charges against the person who tried to assassinate President Trump and conduct his own investigation, instead of allowing the Secret Service and the Department of Justice at the federal level, the people who are charged with protecting the president, from doing it. And this creates a kind of conflict between the duties of the national government and the assertions of power at the state level. And I would like to look at the civil rights controversies through the lens of federalism. Originally, all of the stuff that we're talking about that governs educational associations or universities, private universities, public universities, employment discrimination, those were all state issues. They were state issues under the original Constitution. I've recently been teaching the Federalist Papers, and not one of the most famous Federalist Papers, but Federalist 17. Alexander Hamilton talks about he can't imagine that the national government will ever try to intrude upon employment relations or anything that's really purely local in character. Here's what Hamilton writes. This is in the first paragraph of Federalist 17. The regulation of the mere domestic police of a state appears to me hold out slender allurements to ambition. Commerce, finance, negotiation, and war seem to comprehend all the objects which have the charms for minds governed by that passion, and all the powers necessary to those objects ought, in the first instance, to be lodged in the national depository. The administration of private justice between citizens of the same states, the supervision of agriculture, and of other concerns of a similar nature, all those things, in short, which are proper to be provided for by local legislation, can never be desirable cares of a general jurisdiction. It is therefore improbable that there should exist a disposition in the federal councils to usurp the powers with which they are connected, because the attempt to exercise them would be as troublesome as it would be nugatory. It's a different era that Hamilton was talking about, and maybe the allurements of ambition at the national level give rise to things like the expansions of civil rights laws that have been described by my three colleagues. What I want to talk about is the fact that states have not forfeited entirely their jurisdiction over all of those elements that Hamilton talks about as local matters, and that states can adopt shadow, how should we call it, shadow standards, shadow laws that regulate the area of civil rights in all of its manifestations. And they're beginning to do this in ways that are very interesting and that are, as Professor Melnick said, expanding the range of conflict or the area of conflict. Think about the transgender controversies. How have states reacted to the constitutionalization or the Supreme Court's adoption of transgender ideology in Bostock? Well, they're trying to limit it. They have banned men playing in women's sports, the Fairness in Women's Sports Acts that have been passed in more than a dozen states. They have passed bathroom bills that say men should not be in women's bathrooms and biological women should not be in men's bathrooms. The state of Florida has passed laws that say its teachers must refer to themselves by their own biological pronouns, not by their chosen pronouns. And K through 12 teachers don't like that, but that stuff has all been held up in federal court. And what are these actions? These are actions of state governments intruding on what everyone considers to be national business under the Civil Rights Act and under the Department of Justice's provenance. And what the states are doing in these particular cases is that they're expanding the field of play. They're asserting their own sovereignty against the regime of civil rights. They've done this for decades. Before the Supreme Court, put forward its decision in Students for Fair Admissions and got rid of the diversity justification for affirmative action, many states had banned affirmative action and had done so in admissions, and they with different ranges of success, tried to squeeze out affirmative action in their institutions of higher education. It's the states getting into the area that the national government is in. And I think actually federalism, while it's not what it once was, given the reach of the national government and its oversight of state institutions, is actually one of the greatest avenues for providing limits on the civil rights regime that is out there. And these limits can manifest themselves in different ways, but the state attempts to limit transgender rights provide a kind of model, just as the state attempts to ban affirmative action provide a model. So let's just talk about some of the things that are going on in, I think, the only governor who really gets this in Florida. Now, I think all of these things are, of limited success, and none of them, as Professor Powers mentioned, is getting at the genuine heart of the Civil Rights Act. But all of them chip away at some of its legitimacy. In higher education, the state of Florida, along with a lot of other states, have banned or tried to defund diversity, equity, inclusion offices. They've tried to ban mandatory DEI training for search committees. They've tried to ban mandatory DEI statements for those people who would be applying for jobs in academia or in state government. And all of these things are like limiting how state universities can go about trying to achieve the goals of Title VII or hiring mandates that are informed by diversity. And I think these are important things. They're chipping away at certain aspects of this regime, and I think there are other ways of shaping it. You can go out. States have sovereignty over their universities. That sovereignty is limited by the extent to which the national government funds those universities, but states can control what the general education requirements are in their universities. They can talk about funding the general education requirements within the general values that the state would like to see manifest in its citizens. Therefore, they can get rid of diversity, equity, inclusion informed classes and disciplines from the general education. They can remove sociology, which Florida has done, from the general education. They can also shape how schools of education operate and the kinds of products or the kind of students that schools of education churn out. Last legislative session, Florida passed a bill, House Bill 1291, which regulates the certification process of teachers. And what they said is if the school of education is has a curriculum that is infused with identity politics and a misleading account of American history, it will no longer be able to automatically certify teachers. Like, that's a way in which states can assert their authority and limit the impact of the diversity, equity, inclusion regime or the civil rights regime, however you want to call it. And I think we need creative thinking on all of this from states. And so let's go through some of the things that Professor Powers talked about. One of the great extensions he mentioned of civil rights law is the equation of discrimination with harassment, especially hostile work environment or hostile workplace standards for what harassment would be. Now, this makes total sense to me that there would be an extension from discrimination to harassment. I know that not all conservatives think that, but if discrimination is preventing the hiring of someone on the basis of sex or race, if we're going to be doing that, you could hire people without discriminating against them and then create an environment that makes them not want to stay. So it makes some sense that there would be this extension. But can't states also like put forward their own understanding of what a hostile work environment would be? Can't states regulate the corporations that exist within their borders? Can't states equate mandatory private trainings that talk about that are informed by anti-white ideologies and call those elements of hostile workplace and say that those elements create a hostile work environment? States could get into the areas, the highly contested areas of Title VII on the other side and put companies in a pickle. Now, my hope is that if they would get in that pickle, it would create a kind of retreat from the entire area of law because they'd realize they can't win one way or the other. This may, of course, put great political pressure on the states that would try to do it, but no states have really tried in the area of employment to push back with corresponding state laws. And that would be my recommendation, is that it's great to try to limit the civil rights regime politically through different executive orders, to go through the administrative procedures and create new accreditation standards or new Title IX standards. I think that should be done. But states themselves should be doing many of the same things. I would love to see American states, for instance, to choose another example, to pass through law the DeVos Title IX regulations that guaranteed people due process. If the national government's not going to guarantee a due process, well, darn it, these universities exist within the borders of the states. The states can do it. So they should do it. And then these universities will be put in this catch-22. Will they adhere to the national regulations or to the sovereign regulations of the government that has created them? I think we haven't even yet begun to apply the principles of federalism to the civil rights regime, which is an ironic thing, because if you go back to 1954, you'd think that the entire purpose of the civil rights movement was going to be to abridge the freedom of local and state governments, because it was. The de jure discrimination that was eliminated or, eventually phased out under Brown and the Civil Rights Act and the Elementary and Secondary School Education Acts of the mid-60s, that made it seem like government was the problem. And it's time now that the civil rights regime has gone way beyond regulating governments for the state governments to get back into the action. Thank you.
Scott, that's an excellent note to end on or to launch into a discussion with. I hadn't heard the phrase constitutionalization in a while, somewhat ironic in a post-Roe versus Wade world, because of course, one criticism of Roe versus Wade was that it took something that had been essentially a state level criminal offense and federalized it or constitutionalized it, which Dobbs has now overruled. I think Scott's question, I would probably put to Amy Wax, the idea that states could begin defining terms in federal legislation strikes me as problematic. I mean, they can independently pass laws defining due process, and in fact, they have due process common law, but to actually try to define terms in federal legislation seems problematic at first blush. Amy, do you want to comment on that?
Well, I mean, it is not at all unusual for federal questions to wind up in state court. I mean, that's a pretty routine thing because plaintiffs in almost all cases have the choice to bring their federal causes of action in federal court or in state court. So there's something called concurrent jurisdiction. There are some exceptions to that. And then, of course, there are a lot of state cases, state causes of action that implicate federal laws, where federal law needs to be interpreted to decide the state cause of action. So there's lots of instances where states end up interpreting federal laws. That's not unusual. The sticking point here is that the federal court, or at least the Supreme Court anyway, given the jurisdictional rules that we have for our federal system, the Supreme Court is the ultimate arbiter of the meaning of federal law and of terms in federal law. So even if a case goes up on appeal through the state system, a case that implicates interpreting federal law, either constitutional or statutory, there's a jurisdictional provision, Section 1257, which allows a party to hopscotch over to the federal system at the Supreme Court level. Now, of course, the Supreme Court has to take the case because now the Supreme Court's docket is almost exclusively discretionary. But at the end of the day, the Supreme Court says what federal law means, or it has the power to do that. So if it doesn't like what the state courts are doing, and if parties don't like it, the state courts won't necessarily win the day.
Yes, I think Scott was suggesting state legislatures could codify specific definitions, and
yes, but that will also eventually end up in federal court if challenged.
But
I understand that I've skipped ahead to okay, state legislatures will codify the meaning, and it'll either, if it's contested, it'll either go to federal court or state court. And even if it goes to state court, it's going to end up in federal court. So at the end of the day, what I'm trying to say is at least the federal courts, right, get to say what this stuff means, the federal laws mean.
Yes.
And then, of course, Congress can always change the law. Now, Congress, is pretty much paralyzed right now. They don't do very much. So that might not be a threat. Now, Scott could say, well, it's worth the risk because in many cases it'll pass under the radar screen, and the state can make it stick. That may be entirely true.
Well, also federal courts do sometimes consult what states have done in informing their decisions. So it can be time well spent.
I think on the due process question, the narrow question, the issue is actually a little simpler than that, because no federal regulation issued by any administration has said that you can't have hearings and cross-examination. And if the Biden administration rules were to go through, schools could still keep if they want, or can impose it. So I don't, on the narrow issue of can states define due process in harassment cases in ways that are, entirely consistent with federal regulation, I think that's an easy one. Now, I do say some of your others are harder and raise the questions that Amy raised. But since you brought up Brown versus Board of Education, I got to say, what is the opposition to having states have more control over this? It's the history of the resistance to desegregation. State sovereignty, which I always thought was a terrible term, was discredited, and states pushing back was viewed as defending Jim Crow. And that politically is a very powerful argument to make.
Yeah, I agree with Shep that it all depends on what you're trying to do. And the due process issue with Title IX is a very good one because the federal regulations are, permissive. They essentially give universities permission to have lax standards, right? And that doesn't prevent states from having, or universities for that matter, from having more exacting standards.
That's
Can
right.
I just make a crude political point about what's going on in red states, though, which is, you're right about Brown versus Board of Education, the history, but what has happened in just the past 3 or 4 or 5 years is remarkable. Mm-hmm. This is an unprecedented moment in civil rights history. This pushback by 20 plus states is a sign that wokeness is troubling people. And the state legislatures are trying to figure this out still. Florida's a leader, Texas, a couple places have, done a lot, but many states are kind of feeling their way through this. But it is a sign of a significant change and something that really could be taken advantage of. And I do think the more that states do, the more these issues will be in the public eye, and this will have the kind of effect of a civil rights, civic education that I think we need to have, or at least it will show the need for it. And so I think it's just extremely important.
There's another point here.
I just want to make sure listeners are with us. The references to the Biden administration's newly promulgated Title IX rule, which has been challenged by over 26 state attorneys general, and there are now 10 cases pending where those attorneys general have challenged them on constitutional grounds, statutory grounds, contractual grounds, actually. So what Tom is saying, Professor Powers is saying, is that this pushback by the states is significant.
And it goes beyond Title IX, right? I mean, the issues Scott Yenner was talking about are actually more DEI, going after changing the universities. It's a broad range of all kinds of different issues. Sorry, Scott.
Yeah, well, the Title IX rules, I mean, they've just been struck down over and over again, even by democratically appointed judges. I mean, they go so far. They are, I hate the word extreme, but they are extreme. But the other point to make about trying to regulate what happens in K through 12 and push back against, some of these absurd rules is K through 12, and even Democrats will acknowledge this. Luke Menand, for example, said something in a New Yorker article. They are an area of virtually plenary state authority. Mm-hmm. I mean, the states really can, all of this sort of vague First Amendment rights of professors and academic free expression and, discretion over curriculum. I mean, none of that is incorporated into law. The states have dictatorial powers so far, anyway. It's really only students that have First Amendment rights, and they, I think Tinker was a horrible mistake. So if I had my druthers, they would overrule Tinker, and this would be like a First Amendment free zone, K through 12.
So
yeah.
So I mean, the thing that I would just like to kind of weigh in on the Title IX thing is that I think the superior approach would be for states to define the process that they would like people subject to on their campuses. Mm-hmm. And instead of trying to stop the federal rules from going into place when it comes to these things, I mean, genuinely exercise sovereignty over your public universities so that they're shaped the way you want to shape them. Mm-hmm. And I mean, I'm in favor of the lawsuits, I guess, but like the attitude that I'm trying to put forward is more visible in what Governor DeSantis is doing with the attempted assassin than it is with what the attorney generals are doing when it comes to Title IX. Mm-hmm. Because he's saying this is our jurisdiction and the job you're going to do, like, I don't trust it completely. And therefore, I'm going to kind of take over. This is a crime in Florida. And that's the kind of attitude, I think, that you could put genuine limits on the civil rights regime.
Yeah, fair enough, but not all the states are Florida. We have the issue that a number of states could provide less protection for due process and free speech, as could a number of schools, especially when it comes to the politically charged area of sexual discrimination. So it's just something to keep in mind. The federalism plan is that Alabama is different from New York. I did want to pick up on a point that Tom made. You suggest that the DEI is almost an inevitable evolution of a ban on discrimination. And I want to question that. Is that really your position, that we got to this diversity mania, destructive diversity ideology because of discrimination bans? At first blush, that does not seem correct on the very simplistic sense. Really? That, well, bans on behavior, which are often, criminal bans, for example, are much different from aspirational goals. So the DEI, of course, is taking where the law is very comfortable, which is prohibiting things such as in the criminal code.
Except that, as I laid it out. go ahead. If you want me to answer.
Yeah, so my question is, do you think that in order to truly abolish destructive diversity ideology, you also need to abolish discrimination bans?
No, I mean, you don't need to go that far, but the 1964 Civil Rights Act did not create this system of privatized enforcement of the law.
Fair
And
enough.
so it hands over to corporations this
Yeah.
responsibility, and if they don't do it, and so it really, if you go back to my list, diversity training is this weird case, Kolstad versus American Dental, that no one's ever heard of. Sandra
Right.
Day O'Connor said, you corporations need to teach the civil rights revolution lessons, right? And so what did they do? And they don't know how to do it. And that's a point Scott Yenner just made I'd like to tap into. Government needs to, I think conservatives need to embrace the idea that government needs to write these bloody rules, because otherwise you're going to get Ibram Kendi as the basis of your diversity training, right? And the EEOC should be issuing the diversity training, or state government, or whoever. And that would make it political, because it shouldn't be left to the private sector. This was something that happened in this kind of bizarre way through employer liability laws that no one knows about. And then you tell all these corporations they have to, undertake preventive and corrective measures, and they don't know how to do that. So, we've got to where we are today. DEI absolutely is the lessons, basically diversity, equity, and inclusion. That is a way of talking about the political and moral teaching that corporations have to give to their employees so that they don't treat one another badly and then they get sued. Not the employees. They're not going to get sued. The corporation, right? So
Can I use a partial dissent
not
to
even
this?
indirect. It's not even indirect. It's a straight shot from the law to DEI.
I think there are people always trying to push the envelope. The idea, however, that it's inevitable strikes me as implausible. What we have is sort of the insatiability of the beast. And I think actually the whole gender ideology thing is, one could say that's an extension of the sexual revolution or the homosexual lobby. But I think there are a lot of people comfortable drawing a line, saying we can and should have discrimination bans, but we are not going to go into this diversity ideology, pitting Americans against each other based on ethnicity.
Let me ask you this. What about diversity training? Excuse me, my light turned off. I got to go turn it back on.
Well, for decades, we didn't have diversity training. The 1964 Civil Rights Act.
It's a requirement. It's not voluntary, like maybe you could do it, maybe you can't. Corporations have to have diversity training. And if they don't, I mean, this is what the Eller-Farragut liability test says. It says when you come to court as a corporation who's being sued for harassment, if you can show you have diversity training and all this other stuff, you do, climate surveys, you have a system for bias reporting. If you show all that stuff, the courts are going to be nice to you. If you don't, you're toast. So how is that voluntary?
But that's not, that is not a mandatory way of interpreting Title VII. I mean,
sure
the fact is that
in 1999, 2000, every employment lawyer in the country was telling its corporations, hey, you got to get on board with this. I mean, you can read my book. I got a chapter.
Yeah, I got that, but
I'm sorry.
It didn't have to be that way.
Right.
Yeah, I think.
How would you?
And also,
you have to overturn the Eller-Farragut test. You get rid of the Eller-Farragut test. Okay, but
go ahead,
Farragut was, it didn't have to be decided the way it was decided.
Oh, but it has, and that was in 1998.
Okay,
that was a long time ago.
It's mischievous. Farragut is mischievous.
I agree.
Ellerth is mischievous.
Okay, so
I'm going to issue more of a dissent.
But that is exactly what I'm calling for when I talk about civil rights reform and education. We have to teach people that this happened. People don't know that this happened, that it is from the law. It's an interpretation of the law that didn't have to happen, but it is authoritative. I mean, every employment discrimination textbook. This is, you just start, after the chapter on disparate treatment, you go to Eller-Farragut. I mean, it's basic.
Okay, Tom, let's let Professor Melnick respond. Go ahead.
I'm actually going to dissent on this because I think that the discussion we've had in many conservative circles overlooks a fundamental problem in discrimination law, which is that if you simply say you have a colorblind or a sex-blind policy, whether it be desegregation or employment or whatever, it is extraordinarily hard to enforce. As a matter of fact, it is so easy to evade
Yeah.
That it could have almost no effect, which we have the evidence of the lack of desegregation before 1967. So there's a tendency to say, okay, if we're going to have any real change, we have to have some other way of proceeding. So disparate impact, which I'll be in some ways, disparate impact makes sense because if you see this disparate impact, then you've got to see if there's any justification. We might have gone overboard in saying business necessity, but there's some rationale to that. And the other thing I said, why are we going to people's beliefs? And I think it's in the mistaken understanding that the only way you can bring about real change is to change people's hearts and minds. You have to go deep into private life. Now, I think that's a terrible overreach, but it's a result of the fact that by itself, this formal understanding of civil rights law is insufficient.
Yes, I agree.
Hey, can I offer a
Motive,
different theory?
a lot of this is based on determining motive, which really gets into one's thoughts, one's preferences. It should have been a more sacred region. But yes, Amy, go ahead.
Yeah, I mean, I'm not denying that there was a time, way back when a pure colorblind interpretation of title of the Civil Rights Act would have involved, a lot of attempts at avoiding colorblindness that is continuing to discriminate. But I think in the current era, that is not what is going on, and that's why the interpretation of these laws, the expansive interpretation, is really out of date. I think what's going on right now is what I call the bias narrative, the expectation that if you're colorblind, you will get proportional representation of minorities everywhere and in everything. And that is empirically false. All right? You will not. If you are colorblind, you will see very few blacks in certain places, very few Hispanics, more Asians, because different groups have different interests, talents, competencies, etc. And this is something no one wants to talk about. Just look at universities. I mean, in the Harvard case itself, it was noted that if Harvard were colorblind, and I think that's not going to happen for various reasons, because the federal government doesn't run the Harvard admissions department. But if they were colorblind and a pure academic meritocracy, which they're not obligated to be, by the way. I mean, the SATs are not incorporated into the Equal Protection Clause. But if they were, then the percentage of blacks at Harvard would be under 1%, because they lag behind so badly in academic credentials. So we now have this equity mania, and it is driving everything. Not the old-fashioned worry that people will evade the Civil Rights Act, but rather this equalitarian delusion that in the absence of bias, we'll have equal representation.
I'd like to make a larger point and how unfortunate it is that civil rights laws and discrimination talk focuses so much on groups. I think that's already a very destructive development in the United States, which was historically considered the land of opportunity for individuals. And indeed, virtue and vice, sins, were individual. They were not based on groups. And yet the civil rights regime has sort of taken over the field of moral talk. It's as if the only morality the country is recognizing has to do with identity politics. And in that way, it's a shiny metal object, distracting people from the real task of life, which is to develop good character. And our educational institutions are instrumental in that. And it's largely an individual project to avoid individual vices, to cultivate individual virtues, yet the whole civil rights regime distracts from that. So a great lamentation there. A few questions from the chat. Isn't DEI itself discriminatory and unconstitutional? And why would anyone describe cultural Marxism as a civil rights regime?
Can I say something about the cultural Marxism business?
Sure.
I think that that is a real error by conservatives, that instead of facing the civil rights revolution, which is, I mean, if you look at what I said about Title VII and think for a minute about, how institutions and Title IX together, I mean, it is so pervasive and it comes directly out of the Civil Rights Revolution. Those laws developed. I mean, I had to cut it because of time, but the opinions I cited were decided by Chief Justice Burger, Rehnquist, O'Connor, and Kennedy, all conservatives. And, so it was innocent. It was innocent. I mean, especially Rehnquist and Burger. I mean, and so, and Gorsuch wrote the Bostock decision, right? We didn't talk about, Scott mentioned it, but so this was somewhat innocent. It happened by accident. This was not cultural Marxism. But conservatives today would much rather talk about cultural Marxism and hate on DEI as Marxism because it's easy. You don't have to face the Civil Rights Revolution. Facing the Civil Rights Revolution is not so easy. Talk to Amy Wax and Scott Yenner.
So sort of
I'd say it didn't happen by accident. It happened because all of the civil rights laws we're talking about, all of the decisions of the 1970s were aimed at the problem of how do you destroy the Jim Crow system in the South. Now, I agree completely with Amy and with Chief Justice Roberts. We're in a new era, but that system was built up with that as the enemy largely. So it was an accident. It was history.
Interestingly, though, it applied to the entire country and,
Yes.
And not just to the South, and affected employment practices in places on sex where there wasn't a Jim Crow history,
Right.
and in, all over the North where there wasn't, de jure Jim Crow, at least.
As Strom Thurmond required.
Yeah.
Yeah, I mean,
Well-
school desegregation. I mean, we are the victims of, Jim Crow nostalgia. I'm telling you, we can't let go. I mean, in school desegregation, they were straining to find, incremental segregative effects in northern places where they've never had official. It was all the product of neighborhood segregation. It was all the product of private choices, frankly. I mean, the whole desegregation edifice was based on a delusion, and
Yeah, I
that's
would
why
say-
it collapsed.
In response to what Scott said, you're absolutely
You
right.
wrote a book about it, I know. So,
Yeah. It's
You
an
know,
It's
awesome-
remarkable
I-
how quickly we went from race to sex to disability to sexual orientation. The analogy was so powerful, but often quite inept.
Yes.
Religion's a good one too, because religion is actually now covered. And so conservatives try to use civil rights to tear down the separation of church and state and rethink freedom of religion. Free exercise clause, which used to pertain primarily to religious minorities, is now being used for the Christian majority. That is a real change.
Well, I think that's I was trying to start that with the discussion of the individual nature of vice and sin and how that is being transformed as we speak. Let's take one last question from the chat and then I think we'll wrap up. Amy, I think this might be for you. The American Bar Association, which has regulatory authority over law schools, has taken to saying that reliance on state law, contrary to its rules, is not a reason for non-compliance.
well, I mean, they're just,
The Bar Association.
whistling in the dark over that one. I really would question the legal basis for that.
Yeah, it does raise
I-
the problem of the bar associations, like the law schools, like the state bar associations. They're all
Well,
arguably.
they have been actually relied on by the states to do their dirty work, their sort of their HR department. But remains to be seen whether if something like that is tested in court, if it'll stand up, I mean, a lot of judges will say, well, the states have the ultimate authority in who qualifies as an attorney, and who is allowed to practice as an attorney, not the Bar Association. The Bar Association is there in sufferance.
Well, often the bar association gets weighted a little bit more, for example, in the appointment of judges. But that's another discussion.
Yeah, but there's no requirement that they be.
True, but they have effective lobbies. So, well, all right, everyone. It is now 5 p.m. So I think we've gone the link that we should go. And because everyone was able to actively participate, hooray. I don't think there's any need for closing statements. And I just want to thank everyone for giving their time and talent for today's webinar. And I hope that we can have another event like this maybe next year. So many thanks, and